Two cases before the United States Supreme Court could reshape social media. Justices are set to decide whether state officials can tell companies what they can and cannot allow on their platforms. Washington correspondent Raquel Martin reports on the landmark hearings.
The cases were brought forward after Texas and Florida passed laws banning social media companies from engaging in what they believe is censorship. But those social media companies argue those bans are a violation of their free speech. The Supreme Court is wrestling with yet another 21st century question. Can Texas and Florida stop social media platforms from taking down users' posts, or require the social media sites to explain why they took down the posts? Henry Whitaker is the Florida Solicitor General.
Platforms do not have a First Amendment right to apply their censorship policies in an inconsistent manner.
Whitaker argued the state laws are designed to prevent censorship of conservative speech.
The state has an interest, a First Amendment interest, in promoting in ensuring the free dissemination of ideas.
But the court seemed not to be buying the state's arguments that the First Amendment requires the internet companies to do anything.
The First Amendment doesn't apply to them. The First Amendment restricts what the government can do. And what the government's doing here is saying, you must do this, you must carry these people, you've got to explain if you don't. That's not the First Amendment.
Lawyers from Net Choice, a group that represents social media companies, argued their case in court.
Florida and Texas enacted laws that will force a private business to host lawful but awful content that they just don't want.
Net Choice's VP, Carl Szabo, says ruling in favor of the state laws would set a dangerous precedent.
So left, right, or center, every single American should want to protect our First Amendment rights from the government.
The Biden administration is siding with the social media companies, but Trump, who was kicked off Meta and Twitter following the January 6 riots, is urging the court to uphold the Florida law. For now, in Washington, Raquel Martin, back to you.
And Chief Legal Analyst Khalif Roach joins the conversation now.
All right, so Khalif, what are the social media platforms arguing here, and what are the current rights of these platforms?
I mean, you got to remember how we got here first is that in the wake of former President Trump doing the things during January 6th, making the comments on social media, he was barred from all the social media platforms. And because of that, it sparks Florida and Texas to create these rules, this legislation that would penalize social media companies. Currently, social media companies can do whatever they want because they're private companies. That is something that is a very weird place that we're walking towards with a lot of these arguments right now. There is a light regulation while we're attempting to look at the negative effects that social media has on teens and addiction components that it may have even on adults. There is very, very limited regulation, and there's court findings that support. There is limited regulation on a private company, specifically something such as a social media company. So the argument that they can be restricted in what they have to carry and required to carry on their site seems to be a stretch, to say the least.
So how might the Supreme Court decision influence social media going forward, and also with free speech as well?
It seems like we may not be close to a decision. I don't think they'll come out with one until June, but listening to oral arguments, it was 4+ hours that I listened to earlier, and what I can tell you is they all seemed all over the place. Only two of the justices seemed like they knew where they wanted to go from the very beginning. Alito and Thomas, they knew, like, listen, this seems like censorship, which is a very weird argument because it's normally the Republicans that would be making the argument that states' rights are supposed to be protected and big government is bad. But you're asking the government to come and censor a private company, which is seemingly weird in this instance. However, what I can tell you is the other ones asked questions that really didn't let you know where their hand was, and that's not normal for these type of hearings. Typically in a Supreme Court case, you can tell by the types of questions that they're asking where they're leaning. You really couldn't tell. Chief Justice Roberts made the most open comment of the day by making the comment about that this doesn't even seem like the First Amendment applies because they are private companies. The First Amendment, while it does protect your speech, it's normally protected in public areas. And so the states tried to make the argument that this has now become the public forum. Now, because billions of people use this platform, this is the public square, is what they argued. And when they got pushed back with that public square argument, there really wasn't anything to be said back about it, because at some point you can choose to participate in this argument or you can't. Unlike something where you're an elected official, where that is a public domain and people have to go there because they are elected officials. The arguments are new. These are arguments that folks are trying to make, but I've mentioned this before. When you have folks that really don't utilize the platforms, it makes it for a very interesting argument. And so that's what we're looking at now. Folks that are late 70s, late 60s, trying to make arguments for social media that's going to affect 15, 16, 17-year-olds.
And it's interesting because the internet so far, even though it's decades old, has been fairly unregulated. So, right?
Fairly unregulated, but there are a couple of concerns. I mean, what you're attempting to do is make sure that you don't have hate speech on there, making sure that you don't have things that there are obscenities on there, because there are protections for that. But they have absolute protection from liability. The Florida case will seek to remove that. If they remove a elected official that's running for office, it would remove them and it would subject those social media companies for a lawsuit. And that will go against all of the current standing that's in there right now.
It should be a big decision, landmark decision, precedent that'll be set sometime in June. And all right, Khalif Rhodes, thanks.